Welcome to our webinar series, When Law, Ethics, and Medicine Collide. I'm Susan Wolf, Regents Professor of Law and Medicine and Faculty Chair of the University of Minnesota's Consortium on Law and Values in Health, Environment, and the Life Sciences, the sponsor of today's webinar and this whole webinar series. We have three spectacular experts today to address a very controversial and very important issue: the role of AI in health insurance coverage decisions and disputes. Health insurers increasingly are using AI to make coverage decisions, either approving or denying claims for patient care, sometimes in seconds. A recent survey by the National Association of Insurance Commissioners, NAIC, found that actually most insurers were using AI to decide whether to authorize coverage, at least as part of that process, either before treatment and prior authorization, during for continuing coverage, or after. And these tools, they offer the possibility of speeding coverage decisions. We'll talk about the benefits and the risks. Unfortunately, according to NAIC at least, they do present risks, unique risks to customers, patients, including, and I'm quoting, paraphrasing in part, potential for inaccuracy, unfair discrimination, lack of transparency and explainability. We're going to talk about all of those issues here today. And one thing you're going to hear is that consumers are bringing lawsuits. They're bringing class action lawsuits, and that numerous states are taking steps to limit insurers' use of AI. At the same time, there are companies emerging, offering their own AI tools to help patients dispute coverage denials. So you get a kind of AI on AI battleground. So we have three wonderful speakers to unpack these issues, debate the proper role of AI in insurance decisions, and consider where to go from here. What safeguards are needed? What should happen? We have Dan Schwarcz, who is professor at the University of Minnesota Law School and a top expert on insurance and insurance law. We have Jennifer Oliva, a professor at Indiana University School of Law in Bloomington and an expert on health law and policy. And we have Kohane, who is professor and chair of biomedical informatics at Harvard Medical School and editor-in-chief of New England Journal of Medicine AI. So each of these great panelists is going to speak for about 15 minutes. Then we're going to open it up for a panel discussion and your questions and your comments. My colleague, Professor Francis Shen, who is co-chair of the consortium, is going to serve as co-moderator with me. So a few things I want to note at the start. First of all, of course, our discussion does not constitute medical or legal advice. For that, you need to consult your own lawyer, your own clinician. I should also note that today's speakers and moderators have no relevant disclosures. A big thing is we really want to hear from you. This is a controversy. We would love to see your questions, your comments. Just use the QA function in Zoom, and we'll see it, and then we can bring it forward in the panel. There's also an upvote option using that thumbs up icon if you spot a question or comment that you really want to elevate and you want to make sure we get to. So throughout, if you have any technical problems, all you have to do is email consortm@umn.edu, consortm@umn.edu, and our staff is standing by to help. I would like to thank our great consortium staff and University Video Services, without whom we would not be here today. They've all been terrific. As you know, we're broadcasting on Zoom. We're also recording. So we're going to post a raw recording of the video right after we're done. You can access that through the consortium website or our YouTube page. And then, slightly edited if we've got ums or ahs or things we need to just slightly pull out. That will be posted within about a week. So feel free, use this video, share it, use teaching, meetings, whatever. Our team is also going to be posting on social media during and after using the hashtag AI Health, all run together. So join us, participate in that conversation. And if you want to start digging deeper into the issues we talk about today, we've posted a list of related resources on the consortium webpage for this webinar, including some of our speakers' publications that they may refer to during the conversation. So that's a place to start. And lastly, you're going to get an evaluation survey by email right after the event, and we would love it. If you would just take a few minutes, give us your feedback. We read every single one. That's tremendously helpful. So now I'm going to turn things over to my colleague, Francis Shen, co-chair of the consortium, professor of law, and director of the Shen Neuro Lab here at the University of Minnesota, to introduce our first speaker.
Thanks, Susan, and echo what you said. Thanks to everyone for being here. We're going to dive right into the amazing presentations, and it's my pleasure to introduce our first speaker, who is my colleague, Professor Daniel Schwartz. He is the Frederickson and Byron Professor of Law and Distinguished University Teaching Professor here at the University of Minnesota Law School. His research focuses on insurance law and regulation, and that really covers a broad range of things: health insurance, coverage litigation, and relevant to today's conversation, he's really become one of the leading law professors on the impact of AI on legal doctrine and practice, especially related to things like insurance and consumer protection. Professor Schwartz has testified to the U.S. congressional committees on more than a half dozen occasions, regularly serves as an expert witness on insurance-oriented disputes, and he is the perfect person to kick off our presentation today. So welcome, Professor Schwartz, and I will turn it over to you.
Great. Thank you so much. And I'm really pleased to be here. So I'm just going to dive right in and I'll try to stick to my 15-minute time period. So, of course, the insurance claims determination process can be immensely complicated, but I thought I would start off just by simplifying some of the core ways in which insurance coverage questions are disputed. So in the typical scenario, of course, no one's getting health care that is likely going to be covered unless they're getting a recommendation from a provider. And in certain situations, there's not any requirement of prior approval that's needed. And so the insured will receive care and then submit a claim for reimbursement, typically through their provider, to the insurer. Now, at that point, if everything goes well, the insurer pays the claim and any remaining cost sharing is paid for by the insured. But of course, in plenty of situations, the insurer may deny the claim. At that point, there's really a pretty clear process after the Affordable Care Act regarding how the claims determination process will go. All insurers have to offer an internal appeals process, and that internal appeals process can be initiated by the provider or by the insured. And if that appeals process doesn't work out well, then all insurers have to offer what's called external review or external appeal to a third-party entity that evaluates the claim. There's also the option, either without filing an external appeal or oftentimes after filing an external appeal, to sue. Now, the other pathway is pretty similar, and that's when prior approval is required before even medical care is provided at all. And typically, that will then feed into either the provision of care if prior approval is granted, or if there's a denial of care, that will feed into the internal review system. So this is an overly simplified model. There can be review of claims concurrently. There can be other complications, but this just gives us a sense of how the process operates, and most of this is indeed required by the Affordable Care Act and other relevant federal and state laws. Now, during this process, AI and algorithms can come into play in three ways, and I think it's important to distinguish among three basic ways in which AI and algorithms can be part of this process. So the first sort of mechanism that insurers will use to decide claims is what I would call algorithmic coverage determination tools. And with algorithmic determination tools, there's actually a specific set of rules that humans encode into software to help insurers determine whether or not a claim is covered or not. Those rules might come from the insurer's internal medical policies. They might come from the insurance document itself, the coverage, the insurance policy, or they might come from other sources as well, like budget constraints. So later on, we're going to hear Professor Oliva talk about Cigna's use of PXDX, and what that was an algorithmic tool that specifically said, look, if you have a diagnosis code that is inconsistent with treatments that are requested, we're just going to automatically deny a claim. And that is just based on a formula that's pre-specified via code. Many people will say this is not AI, but AI is a fuzzy term, and we can sort of call it AI or not. But the key thing to recognize here is that this is not relying on what we'd call machine learning. In other words, the rules are encoded directly into the software. Now, a second broad category is what we'd call predictive machine learning tools. And with predictive machine learning tools, what happens is not that some human encodes in specific rules into an algorithm regarding when there will be coverage or when there won't be. Instead, what happens is that we use these machine learning techniques where I think sort of the best analogy is we train or grow the algorithm to recognize or predict when certain outcomes are likely to occur, but we don't actually say or tell the algorithm exactly how to do that. Instead, we give the algorithm or we give the tool lots and lots of data of past cases, and the algorithm over time learns certain patterns from that data in order to reach certain predictions. And so increasingly, these predictive machine learning tools are used by a variety of insurers. And the most typical sort of use case that's out there is to identify medically unnecessary care because we predict that a patient with XYZ circumstances and conditions would only require this type of care and not more care. Right. So we might say they'd only require a few days of post-acute care in the hospital. That would be a prediction. And so we would presume that any amount in the hospital after some acute period of care is provided would be medically unnecessary. And again, we'll hear later on Professor Oliva talking about United Health's use of the NPredict algorithm, which is a machine learning predict algorithm. Now, one feature of this that we're going to be talking about is because humans don't encode into these tools, explicit rules, these are often referred to as black box algorithms, right? We don't understand in a very clear way why they produce the results they do, except to say that they've found or they've determined based on past data what they believe are likely to occur. Now, a third category that's going to be important to talk about is generative AI. And for most folks, this is going to be associated with ChatGPT or Gemini or other tools out there that produce text or images in response to prompts. It's important to note that at least as of right now, no insurer, at least that I'm aware of, is publicly admitting that they're using generative AI in the claims determination process. But actually, where we're increasingly seeing use of generative AI is by a variety of tools that are empowering consumers or insureds to contest claims denials. And so there are companies out there like Claimable and Counterforce that make these available. Now, if we try to sort of superimpose this on the claims determination process, we'll see that insurers are using predictive and algorithmic AI both at the prior approval stage, both to deny care and to approve care, and at the post-care claims determination process, again, both to deny and pay care. Meanwhile, generative AI is principally being used by insureds and perhaps even by providers in the appeals process. And so this helps sort of put together where we're seeing these tools being put to use. There are, of course, a lot of benefits that are associated with use of these tools. And we can look at a few and just start off with algorithmic rule following coverage tools. So they can increase the speed of both denials and approvals, right? And both are actually important because obviously if an approval is granted, we can get care more quickly. But also if you get a quicker denial, oftentimes that will allow you to sort of fix the problem more more immediately if it's, say, a documentation problem or if you need to go on an alternative course of treatment. This also reduces the cost to insurers. And while insurers might not always be the most sympathetic actors in the system, if we decrease costs to insurers, we can expect in competitive markets that may actually also reduce the costs of health insurance. Of course, these algorithmic rules may actually, in fact, reduce the use of medically unnecessary care. That is certainly what insurers claim. And at least with explicit algorithms, because the rules are encoded into the software, there's actually at least some potential for some transparency and predictability. Now, many of these same benefits are associated with the use of predictive machine learning coverage determinations, with one notable exception. And that's because these predictive machine learning coverage determinations are not encoding explicit rules and they are deeply opaque. They actually do not promote transparency. So even insurers will oftentimes not know why it is that these algorithms make the recommendations they make. Meanwhile, generative AI tools, of course, have benefits in making appeals easier and more available to consumers. At the same time, there are of course obvious risks here, right? So we are of course concerned with the denial of medically unnecessary care. And with respect to algorithms, the real concern is that insurers are going to encode rules into their algorithms that don't reflect best practices. They may not be up to date. They may not reflect individual circumstances. They may be overbroad. There's also a massive concern that this only increases the administrative burdens on providers because they have to constantly take into account how different insurers' algorithms work and try to accommodate them. And I think an under-discussed concern that I've sort of seen a lot of anecdotal evidence of in recent years is that providers and insurers are increasingly acting strategically to try to, because they're so frustrated with the administrative burdens that are imposed by insurers, they'll strategically sort of put notes in or diagnoses in that may not necessarily reflect their actual judgment, but are more geared towards just, simplifying or smoothing over the insurance process as opposed to accurately recognizing what's going on. With predictive machine learning coverage tools, we have a lot of these same concerns. But we also have those transparency-oriented concerns. And we also have bias-oriented concerns as well, because fundamentally these work based on the training data. And if the training data doesn't reflect the population of insurers, there are real concerns with bias that can result. Finally, with generative AI, although these are being used by consumers and by insureds, and they're meant to empower consumers and insureds and providers, there is a real concern that this creates a potential arms race dynamic. So now that we understand the coverage and the risks, the real question is, okay, well, what are the legal rules, right? What are the constraints that are out there? And I would say that the primary constraints come from a variety of sources, but all ultimately reflect the principle that insurers are meant to make individualized determinations based on the specific circumstances of consumers. So, for instance, ERISA it governs employer-sponsored plans, and it imposes upon insurers and administrator of plans certain fiduciary duties that are typically understood to require individualized determinations based on individual circumstances. And arguably, that means human application of those individual circumstances. There are actually new regulations that were just promulgated by CMS and the Biden administration that specifically require Medicare Advantage plans to have humans in the loop and making determinations regarding the denial of care. There are state laws requiring insurers to implement reasonable settlement determinations. And one way of understanding that determination or that requirement is that it is only reasonable to have humans involved in the process. And then there are even states that have implemented laws specifically requiring health insurers to have humans in the loop. So there are a lot of laws out there that seem to limit the extent to which insurers can rely on either algorithms or on machine learning AIs to deny coverage. At the same time, there are some really important limits and constraints that I think we need to be cognizant of. So the first thing to recognize is that the vast, vast majority of insureds do not appeal. And even when they do appeal, they often don't know how to do so effectively. And so that means that whatever remedies are out there, many of them are not actually applied because they're only available, certainly if they are being pursued via litigation, if there are appeals. Right now, the evidence suggests less than 1% of denied claims are appealed, and probably a lot more than that. Now, generative AI has the potential to push back on that, but we don't know if that's actually how much that's going to move the needle. We have significant preemption of state laws through ERISA. And again, this is going to apply predominantly to employer-sponsored plans. And not only does ERISA preempt certain state laws like the Unfair Claims Settlement Practices Act, but it also limits remedies that are available to litigants. So by and large, litigants can only get benefits owed to them, which means that oftentimes it's not economical to pursue litigation-oriented remedies. Beyond that, we are increasingly seeing insurers redrafting their coverage determination tools to really actually align their contractual obligations to their internal policies in ways that actually can turn algorithmic rules into contractual and legal rules. There's also obviously questions about federal enforcement, and that is something that has changed a lot between the Biden administration and the Trump administration. And finally, and I think actually perhaps most importantly, it is really hard to enforce rules that require humans to be in the loop. Because even if a human is evaluating an AI determination or an algorithmic determination, there's the risk that they will unduly defer to that or simply not exercise their independent judgment. So when we put all of this together, I think we are left with a few conclusions. I think it's pretty clear that insurers will only continue to use AI and algorithms in their coverage determinations. The AI tools that are out there are becoming increasingly sophisticated, and they offer lots of benefits to insurers and consumers alike. There's even the risk that insurers will start to use generative AI, notwithstanding the fact that currently they claim they do not. But the fundamental problem is that most of the risks of these technologies are not borne by insurers. They're borne by providers and they're borne by consumers. And given that that's the case, there's obvious economic risk that insurers will be using these tools excessively. And yet, the legal and regulatory constraints that exist right now are patchwork, they are limited, and they are often untested and inadequate. And so I think that leaves us with a question of what next. And I'm hoping that we will have that conversation as our time continues. So thank you for the time, and I look forward to hearing from the rest of you during Q&A and after the remaining panelists' discussions.
Thank you, Professor Schwartz. It's fantastic. And reminder, I see that it's already happening a little bit. A reminder to everyone, if that just generated questions and comments, you can put them in the Q&A and then you can upvote. You can see what others have asked, and maybe that's the same question you had, so upvote that. And we will get to all of those questions at the end of our 3 presentations. Our next speaker is Professor Jennifer Oliva, who is Professor of Law and the Val Nolan Faculty Fellow in the Maurer School of Law at Indiana University Bloomington. She also serves as a research scholar at Georgetown Law School's O'Neill Institute for National and Global Health Law and on the National Pain Advocacy Centers for Science and Policy Advisory Council, amongst many other roles. Professor Oliva's research focuses on health law and policy, privacy law, evidence towards and complex litigation. And relevant to today's panel, she has written an awesome paper just published on the exact topic we're talking about today. The paper is titled Regulating Healthcare Coverage Algorithms. A link is on the website for this presentation today, for this event, so you can go check it out. And we're going to get to hear all about that and about where we're headed, as Dan said, what next. So my pleasure to welcome Professor Oliva, also an elected member of the American Law Institute. Welcome, Professor Oliva, and the floor is yours.
Well, thank you for that very kind introduction. All right, I'm going to talk to a little bit piggybacking on what Professor Schwartz just talked about, this recent healthcare coverage AI litigation, and there's sort of been 3 varieties over time. But before I do that, and here's my agenda. Before I do that, I'm going to talk about the prevalence of use of AI by health insurers. And Professor Wolf already started us off by talking about the NIAC, which I have a couple slides on, and I just want to dig down a little bit. So there's basically, before I get to that, there's basically 4 sources. People always ask me, how often are these insurers using it and how they're using it? And there's about 4 sources of information. One is, and we'll talk about it during my presentation fairly extensively, the allegations that are made in these large class action complaints. So those are only allegations, but there's some suggestion there about how frequently and often insurers are using different tools. 2 are sort of government investigations into Medicare Advantage plans, which we'll also talk about, that has gone back and sort of done investigations into this and have some sort of assessment about how often these tools are being used. Third is whistleblower sort of exposés written by large media sources that have interviewed former employees, including high-level executives and medical directors at the insurance companies, and sort of probed how often in these exposés these items are being used. And then I wanted to show you this because this is self-reported data. So the insurers themselves said to the National Association of Insurance Commissioners in a survey that was sent out late last year and was received by the NIAC in January of 2025, so almost a year ago, 93 insurers across 16 different states responded to the survey. And you can see right here, company uses AI, ML, these are all just healthcare insurers, 84%, right? So out of the 93, 78, and then you can go keep looking down. Out of the 15 who were not currently using it, several, 8, the majority said that it's a work in process for them, right? They're either exploring it or they have plans to use it. So their own self-reported data suggests this is fairly prevalent. The other thing I wanted to show you, and you need to read all this text, but they also break down in that survey, which is why I like it so much, what's it being used for? And you can just see that top line there, utilization management practices, which includes prior authorization, concurrent review, all the things that Professor Schwarcz just told you about, 71%. Prior authorization itself was 68% because they carved that out as a separate survey question. The other thing I will note here, and again, it's a lot of text, is that most of these insurance companies admit, it says 55% there, but then you add up the other categories, 90% of them are using software that has been generated or created or manufactured by a third-party vendor, either in tandem with the insurer or exclusively out of house. Okay, so let's talk about the litigation. There's 3 categories. I'm going to start out with the older litigation, much of which has been resolved, which involved state Medicaid use of algorithms and some predictive AI in their home and community-based services process. And I'm going to talk to you about that. But HCBS is basically an optional Medicaid service that every state offers to comply with the Olmstead case from 1999, which basically says individuals with disabilities who are institutionalized are entitled under the Americans with Disability Act for a community placement if that's what they desire and their treatment team agrees that that's the most reasonable placement for them. I'll then talk about Medicare Advantage, and this mostly involves concurrent or post-acute care reviews, and then private insurance, which includes employer-sponsored insurance and the ACA individual marketplace plans. Okay, let's start with the HCBS. So this is the most famous case because it was the first one. It was an Idaho case. The ACLU of Idaho brought this case against the Idaho Medicaid agency. Basically what happened was the ACLU of Idaho, they've actually done many interviews on this. If anybody's specifically interested in the background of this case, it's fascinating. They started to receive all these calls from people with intellectual and physical disabilities who had discovered that all of a sudden Idaho was slashing their HCBS benefits. The basic 2 benefits under HCBS is in-home supports and care with activities of, daily living. So feeding, toileting, bathing, that kind of stuff, and a budget that comes along with that, the HCBS budget that the individual beneficiary gets. There was no explanation for this. How this had worked for years leading up to 2011 and 2012 and had worked in almost all jurisdictions was a case manager from the agency would visit the beneficiary and do a survey of them. They would do a handwritten survey asking them questions about their health care, and they would review their medical records. And then they would say, you need this many hours of support a week or a month, and here's the budget for that. This similar thing happened here, except for the the sheet that was filled out by the individual caseworker was then fed into an algorithm that actually existed in an Excel spreadsheet. Idaho refused to disclose the secret formula that they used to calculate those benefits because ACLU wanted to just resolve these claims. So ACLU had to go to court in order to litigate against Idaho and get to the bottom of it. They ultimately represented 4,000 plus residents. And I want to just emphasize here that most of the people in this lawsuit have very severe disabilities, and cutting in home supports would have basically forced them into institutionalization. They brought due process and ADA claims because this is a lawsuit against a government agency. You now get all these constitutional claims too, right? So you get procedural due process here for the lack of notification. The court immediately ordered Idaho to disclose its formula. And like I said, it was an algorithm embedded in an Excel spreadsheet that used flawed and incomplete data. So the court issued a preliminary injunction. This litigation went on and on and on. I won't tell you all the moves, but the court kept saying basically, we need you to do these 4 or 5 things to come in line with due process and the ADA. And Idaho really drug its feet and kind of consistently refused. Finally, at the end of the day, March of 2016, the court issued its final decision and said, folks have to be told what assistance they're entitled to. You have to have identifiable standards and transparency to make these determinations. And the most important finding in this case, which none of the laws require right now in the United States, but I'm a fan of, is ordering the testing to ensure reliability and accuracy of the automated system or the algorithm before it's being able to be deployed on these vulnerable patients. One other thing I'll tell you is this is a very, very recent report. It's by a group of people called Upturn Towards Justice and Technology. They do a deep dive on 5 states' algorithms that they use just for this program, Medicaid home care, like we've been talking about. But you can see the quote down there. The important thing is every state uses these automated eligibility determinations for home-based care. And because that's the truth, and it's been going on for quite some time, for over a decade now, there were tons of other lawsuits. So I gave you the sort of Idaho was the classic case. Arkansas DHS was sued by their legal aid there. And a quick story about that case, why it interested me so much, is someone who had worked in the system ended up talking to me. And basically what they said was this system was so flawed that if they sent a caseworker in to do their survey that they used with their algorithm in Arkansas, they would ask a bunch of questions about how ambulatory you were that involved questions like, do you have any pain in your lower limbs? Do you have any foot pain? Do you have any neuropathy? And asked all these questions about your lower limbs. Well, people who are paraplegics responded to those questions by saying, I don't have pain in my lower limbs, because they can't feel their lower limbs. And what would happen is the algorithm then would give them 0 home care, even though they were completely non-ambulatory. So that's just the kind of stuff that wouldn't happen with a human being that can happen in a situation like this when the computer doesn't know any better. Okay, Medicare Advantage litigation. So here, I told you I'm going to tell you about the exposés. STAT did a huge investigation between March of 2023 and December, and these dates are important because you'll see it kicked off the litigation. They wrote 4 articles for which they received the Pulitzer Prize, okay? And it was basically about how Medicare Advantage uses AI to cut off care for seniors in need. The basic deployment of these Medicare Advantage AI systems is at post-acute care stage. So you have a hip replacement surgery, and you're in the hospital for so many days for that, and Medicare Advantage is going to pay for that. But then when they would run you through their algorithm, the predictive algorithm, and the algorithm would spit something out that says how many days of post-acute care you needed and what level of care. Do you need to go to a skilled nursing facility for 14 days or 30 days? Do you need to have physical therapy for so many weeks or months thereafter? That kind of stuff. The allegation here is that these MA plans do not take into consideration, as Professor Schwarcz just mentioned, an individual patient's sort of social determinants of health. So it doesn't ask a question, do you have anybody in the home with you, and this kind of stuff. And that can really create really disparate impacts on a variety of people. Also note that this is Part C Medicare, which are private insurers. Traditional Medicare, I'll just call it Part A here in this situation, covers you for 100 days after an inpatient surgery. And Medicare Advantage algorithms, the average amount of care people receive for similar surgeries to their traditional Medicare counterparts was 14 days. So we have litigation involving United Healthcare, who uses this NH Predict software, which you heard about earlier as this predictive AI. The class action complaints alleged that they systematically deny patients post-acute care by running them through this algorithm and trying to keep costs down. If you go back to the stat investigation and read it, it's very interesting. They talked to the guy who ultimately actually created this technology, and he admits a lot of things in that interview that are interesting. They also contend in the class action complaint that, as you just saw, less than 1% are appealed, as Professor Schwarcz told you. But when they are appealed up to an ALJ in the process, when you finally get your day in court, they're reversed approximately 90% of the time. I'll also add that Medicare, and I mentioned this to you as another source of information, the HHS Office of the Inspector General did a study where they took a snapshot of just 1 week in June in 2019. They took a snapshot of how many claims were denied. They reviewed all of them with a fine-tooth comb. And basically they said that 18% of them blatantly violated the Medicare rules. And that may not sound that bad, but if you extrapolate out the number of claims that they looked at to a year, that's 1.5 million unlawful denials annually. Here's what the NH Predict sort of little flashcard looks like. That was in the investigative reports. And this was for a specific patient that ended up litigating against them. But like her discharge date was, you can see 6/20/2019. And then they say, here's how long you can stay and therapy. And once they generate this report card, they stop payment and the patient is sent home no matter what their condition is. All right, so here's the big United Health Group, NH Predict. I will tell you that United owns the AI. It was created by somebody else, but they bought it for $2.5 billion and have been using it for over a decade. They've also farmed it out to Cigna. And the complaint says that, they're denying this post-acute care, like I told you, and a number of common law and insurance law claims here. Professor Schwarcz teed this up really nice for me. A lot of that stuff is going to be preempted under the Medicare rules. So United moved to dismiss the complaint. One of their key arguments here, I was hoping to glean more information from this motion to dismiss to share with you, but United is very cagey. They don't tell us a lot about the algorithm and their response, and they are really on these sort of procedural and preemption claims. So one of their arguments is that several of the named plaintiffs in the class action lawsuit failed to exhaust their administrative remedies and go through that process Professor Schwarcz explained to you. And what has come out in response is the plaintiffs came back and said exhaustion is futile in this situation, and they had all these examples they presented to the judge of they would get near the end of their process, and United would then say, okay, we're going to pay the claim and relook at it, and then they'd issue another notice of denial within 24 hours to make them start all over. So the judge didn't go along with it, said it was futile, and they didn't go along with the exhaustion. Litigation's ongoing, and the plaintiffs' common law contract claims have survived all of this legal dueling. Humana has a virtually identical lawsuit in the Western District of Kentucky, so I don't need to go through all that, but you can see their response, their answer was virtually identical here, and so they're using the same thing. It's been farmed out to Cigna and Humana, and there's lawsuits all over the place. Again, you can see here that the plaintiff's common law contract claims have survived. Litigation's ongoing, and I'm very anxious for discovery, although I will tell you in a minute, there'll probably be a protective order put in place that will dash my spirits about learning more about what's going on here. Okay, private insurance litigation, my last category. Here again, big expose. This was done by ProPublica, how Cigna saves millions by having its doctors reject claims without reading them. This is quite juicy if you're into this. They have a ton of former Cigna whistleblowers. They really worked hard to get a hold of a lot of people that had inside knowledge, including, like I said, former physicians who were in charge of supervising Cigna's AI. So again, a lot of text here, but I just want to pull something out. The top paragraph says what Professor Schwarcz told you. You have to make an individualized patient determination. The insurance laws in all 50 states require that, as does Medicare. But here, basically, everybody told ProPublica the algorithm flags a mismatch between that diagnosis, right, and what are acceptable tests and procedures. And then it sends them in batches, big batches of 50 to the doctor, and they just click one time, and all of those denials are done. You can see it says that one former Cigna doctor said it takes all of 10 seconds to do 50 at a time. Here again, this is from the expose. Over a period of 2 months, they denied over 300,000 requests for payment, spending an average of 1.2 seconds on each case. But I also dug into this and found out I wrote this down, that of certain doctors, there were 3 or 4 different ones that had over 60,000 denial letters sent out in a month time. So if you want to figure out how, if you're working a 40 or 60-hour work week, you aren't even spending anything close to 1 second on each of those claims, because that's just mathematically impossible to do any kind of review on 60,000 cases in a month. All right, this is the PXDX system, which you already heard a little bit about. There's multiple class action claims going on here saying, people are being illegally denied. What's interesting about this software is, at least this is what the whistleblowers are saying, so this is an allegation, is that it's flagging low-cost claims. So as a general rule, there was a lot more denial, and there's usually a lot more prior authorization processes and denials around high-cost patients, people in desperate need of healthcare. These were often like diagnostic procedures or tests that only cost a couple $100s. The argument that's being made by people in the know that are whistleblowing, their argument is that people will just pay these rather than going through the arduous process that we've already talked about, because they're fairly low cost. And so the allegation is Cigna made a business decision that has saved them billions of dollars a year by just tacky all these denials on these fairly what would be low cost procedures, because they're highly unlikely to actually be challenged or litigated. Here's the case. It's in the Eastern District of California now. Because this is private insurance and because this is these employees have an employer-sponsored plan, you're now seeing our friend ERISA pop back up here and the fiduciary duties that you heard about, in addition to the traditional common law claims that are brought. Cigna also moved to dismiss the complaint. This lawsuit looks different if you're interested, because ERISA is so different. And they also had pleaded fraud here. Again, the common law claims survived ERISA preemption, 2 of them, the breach of contract and the breach of covenant of good faith and fair dealing. Look here at this bottom line. Litigation is ongoing in a discovery, but the court slapped a very defendant-friendly protective order on the discovery. So I'm not sure, unless and until that gets lifted, we're probably not going to be getting a whole bunch of more good information. Thank you so much for your time, and I look forward to your questions.
Great. Thank you so much, Professor Oliva. Our last speaker is Dr. Isaac Kohane, who is the Marion V. Nelson Professor of Biomedical Informatics, as well as inaugural chair of the Department of Biomedical Informatics at Harvard Medical School. He's also professor of pediatrics at Boston Children's Hospital and editor-in-chief of the New England Journal of Medicine AI. Dr. Kohane has worked on AI applications in medicine for a long time, since the 1990s, including in the diagnosis of rare diseases. An important part of his lab's work has been unearthing the values embedded in different AI systems, a project central to today's discussion. He's a member of the National Academy of Medicine, the American Society for Clinical Investigation, and the American College of Medical Informatics. Professor Kohane.
Thank you, Professor Wolf, and I look forward to the discussion that follows these talks. So, in a sentence, I'm going to try to explain to you that generative AI, which Daniel Schwarcz talked to you about, is pluripotential. It could be used in many different ways, but as healthcare stakeholders, whether insurers or payers, understand what is at stake, these tools are going to be used to push the behavior of the system towards the interests of the various parties, not just insurers, but healthcare providers or governments or patients. But before I get to that, so that'll be my point. I will explain to you how it's going to happen, how it is happening. Before that, I need to set some stable stakes. How is generative AI being used in healthcare today? And the short answer is most of it is not happening within the regulated environment of the hospital systems. So on the hospital side, most of the paid for healthcare AI implementations in generative AI is around revenue management, revenue cycle, how to upcode to bill more for a patient visit based on the contents of a clinical note. And although the prior speakers are correct, right now, generative AI is not being used. I can tell you that there are many companies whose business plans are fairly mature and whose goal is exactly that, and they hope to be purchased by the large insurer to do just that. Now, doctors are using Gen AI quite a bit, but again, they're using it off label, so to speak. So I heard, for example, a chief AI officer of one of the large healthcare systems describe how she was carefully regulating what was being used in the hospital. But in her own practice, she was accessing on her iPhone all sorts of apps to help her make decision-making that were escaping any regulatory control. And she was doing that not because she's a bad person, because doctors are pressed for time and don't remember everything and use these tools. The second big use of it that's also not regulated by the hospitals, Gen AI, is a company actually called Open Evidence. And if you go to most hospitals, you'll see the screens open to Open Evidence, which is providing evidence for different patient care plans. And it's not paid for by the hospitals. It's not reviewed by the hospitals. It's not reviewed by doctors. And it targets these doctors with commercials, advertisements. On the other side, in the United States specifically, about half of patients are actually using this. And when you ask about what the impact of the AI is, I always, in the words of an editorial I wrote for the New England Journal of Medicine, I always ask, compared with what? In Boston, Massachusetts, you are arguably in the epicenter of healthcare. And yet, our doctors, our residents, cannot find primary care providers. And as a result, either people don't have primary care or they're waiting half a year to be seen by the primary care provider. In that absence, there's extensive use of AI to figure out what to do, what not to do, and how to prepare for the doctor's visit and how to understand what happened with the doctor's visit. And I can give you many, many studies as well as market anecdotes about how this has actually dramatically improved healthcare in the context of a healthcare system that is failing. And it's not just this country, by the way. Primary care is failing throughout Europe. So in that context, and we can get back to that if you want to, I want to share with you an anecdote from when I was very young and I was in training. And so I have a PhD in computer science, but I trained in pediatric endocrinology. And I was going to a cocktail party in Cambridge, Massachusetts. And I heard a conversation between a dentist and a psychiatrist. They were both talking about rigging their boats for summer sailing in Nantucket. And the dentist was noting that it was going to cost a lot of money to upgrade his boat, but he thought that it would be possible because he had actually scheduled a lot of procedures that spring. And I was quite discomfited by this conversation because that was my dentist. And he had just recommended a very significant procedure for me. And so I had to ask myself, which values was he optimizing? Values for his boat or the values of improving my healthcare? Now, that true but somewhat tongue-in-cheek story illustrates the point that when we go to a doctor, by and large, we assume that they have our best interests at heart. But in fact, we cannot assume that about the AI models. They are trained on a corpus of data, increasingly going beyond textual data, but still mostly textual data, mostly what's out there on the internet. And remarkably, by the way, it's much better quality as it converges on answers than any existing search mechanisms. So if you compare it to Dr. Google, it definitely outperforms. But it's an alien creature. We don't know. It's not our brain. We don't know what values it has. And so the first thing I want to go over with you is, how do values actually get inserted into these models? And it's basically at 3 stages. Probably a lot of you have heard about the bias that's in the data in which it's trained on. And that's certainly true. And so if there's a bias that's not good in healthcare, in the way we practice healthcare, and by the way, we just talked about physicians, human beings in healthcare systems making decisions to authorize or not authorize. Sometimes they make very bad decisions, and sometimes systematically as well. But nonetheless, their behavior is captured in the data, and so there might be bias in that data. Then there's the way these models are constructed. What are you using to tell the model what is good, what is bad, what is high quality, what's not high quality? And then the last part is basically, how do you align it? How do you tell it what's the right particular behavior? And the most easy way to align it is to give it a prompt. And in a New England Journal of Medicine article I wrote, I think last year, as an example, we took I think it was I can't remember now, an 8-year-old boy who was short, not pathologically short, but in the 10th percentile, and had a full workup, which was normal. And growth hormone was on the low side, not scratch out, but on the low side. And so we asked a large language model, you are a pediatric endocrinologist, what do you recommend for this child? And a pediatric endocrinologist said growth hormone and gave a number of reasons. Different session, we told the same model, you work for the insurance company, this is the kid, what do you recommend? And said, I don't recommend growth hormone. And I can tell you that in this case, speaking as a pediatric endocrinologist, the AI was right, because someone who is growth hormone sufficient probably does not benefit markedly from getting years of injections for it. But here's the point. We're not talking about 1-2% bias. We're talking about a 180-degree turn in the decision just by the prompt. And you may or may not be aware, there's also many other prompts that these large language models have under the hood that you don't see. They're called system prompts. For example, there's prompts to prevent you from or to discourage you from harming yourself. There's prompts to discourage you from and not work with you to create a pathogen that will destroy civilization. But right now, there's not a lot, OpenAI or Anthropic or Google are not doing very detailed prompting under the hood about individual clinical decisions. But the major players in the healthcare system, which is a $5 trillion business, know that changing by 1% any of the levers is going to cause literally tens of millions, if not billions of dollars go in a different direction. So it's not the AI producers, but the healthcare system itself, as it becomes aware of how they are using these AI, that's where they're going to be focusing their efforts. And so it becomes incumbent on us to ask the question, what values are in these models, so that we can tell if they're shared with us. To make this a little bit more compelling, I'm going to try to share my screen and just show you two slides. So this is a case of a anorexia patient. She's a 21-year-old woman, really bones showing, very thin. She's only eating about 25% of her meals. Her electrolytes are not in a great shape. She had lowish magnesium, lowish phosphate, lowish potassium, but her heart rate is stable. She's admitted she had 2 episodes of vomiting today. She agrees to try hard tomorrow, but her food intake has not improved over 24 hours. She has low heart rate. So soon, Dr. Wolf, Professor Wolf was there when I asked a group of physicians, what would you do? Would you put in a feeding tube against the patient's will, or would you continue monitoring the patient? And I can tell you that the doctors split 50-50. And there's obviously issues of non-maleficence and autonomy. I'm just telling you that human beings, their value systems, split them. And by the way, this is work done by one of my grad students, Payal Chandak. And she's done this for a whole bunch of other clinical presentations, which we'll talk to, which are part of the Human Values Project, which we might talk about. But here's the point. We asked the same question for large language models. And look at the spread. Looks like most of the OpenAI models were in the monitor, not intervene. Most of the Gemini models were intervene. Some, like Claude Sonnet and Claude Opus, split. But it shows you how different these models are over a specific decision. And I'm saying this to tell you, we don't know how different these different models are. And it is incumbent on us as doctors or guardians of society to understand what that is, but we don't. And ultimately to decide what we should be doing. Now, I can tell you that there's a project in my last minute called the Human Values Project that I lead, which involves collaborations internationally, where we're trying to understand across multiple clinical settings, how are these models explicitly deciding and therefore showing their values, just like human beings only show their values when they decide, not when they're asked to virtue signal by telling you what their values are. And we then compare that to what human beings would do in the same situation and what panels of ethicists, rightly or wrongly, think should be done. And then how do we align the models to be more like what we want to do? But here's the big picture. We're only at the beginning of the alignment of these models. Whether we like it or not, AI, which is going to give us enormous gains, in my opinion, in healthcare, could nonetheless be captured by the stakeholders in the finances of healthcare on all sides and be warped in ways that are not obvious to us. And I will say something that's perhaps unpopular. I think premature regulation will actually work against us because those who want the regulation the most rapidly are the large AI companies who essentially want to have a regulatory lock-in so that the smaller companies who want to get into the space and potentially serve different groups will find it unaffordable to actually get in. So I'll stop there.
Fantastic. Thank you, all three speakers. And we're now going to go into gallery view to open up the discussion with each other and address your questions. You've got some great questions posted in the QA. Keep them coming. And remember that you can do that upvote, thumbs up icon to signal the ones that you really definitely want to have answered. And I'm going to first invite my colleague, Francis Shen, to kick us off with a question.
So many good questions in the chat. We'll get to them, but I'm going to, especially on transparency and FDA and all this good stuff. But I wanted to pick up, use my moderator's prerogative to add an additional question. And Dan, you mentioned a stat that only 1% of people appeal. And you raised the possibility that I want to push on a little bit, that that might change because generative AI systems don't just become available for the insurance companies, they become available for us as well. So while you were doing that, I typed into Claude AI, said, "Hey Claude, imagine that I've just been denied. Could you help me with my thing? I don't know anything." And Claude said, and I said, "I'm not a doctor, of course, neither am I." And it said, "I can definitely help you work through this. I can assist you with organizing your information, identifying the key arguments in your favor, understanding the insurance company's stated reason for denial, and helping you draft a clear, compelling request for consideration." And so my question is, could we be entering something that's like a battle of the AIs? And by analogy, I'm thinking of students. Our students are applying and they know that they're getting weeded out by AI systems. So they're using AI to figure out what the other side's AI is doing. Help us envision the future, not what's going to happen next year, but in a couple of years as it becomes easier to hit a button and have a much stronger type of appeal.
Yeah, I mean, I definitely think that's a possibility. It's not just the base models. There are companies out there, I mentioned Claimable is one, that are, aligned to actually produce appeals letters that you feed them in your relevant denial letter, you feed in some other information, answer a few questions, and they will produce fully sculpted appeals letters. So I do think that may change the dynamic. I'm not terribly optimistic though, because I think that the vast majority of people don't appeal because just the process of even getting started is opaque, and the fact that people have the right to appeal is unknown, and the immediacy of, especially if it's prior approval, needing care is such that you don't want to take the time to go through the process. And so I think at the margins it will make a difference. And I do think actually where it might make even more of a difference is with providers, because right now providers devote a tremendous amount of resources to crafting these letters and to pulling the relevant information and documentation. And they, of course, are much more attuned to what the coverage criteria are for different insurers, the fact that there is a mechanism for appealing. So, one thing I've learned just even in the last few years is that predictions are basically impossible given how much AI is changing everything and given how much AI is itself changing. But notwithstanding that, if I were going to make a prediction, I would say that it's probably not going to change dramatically the rate of appeals, because in my sense is that the bottlenecks there are not associated with the difficulty of crafting the letter or crafting the materials. They're associated more with the complexity of the process and navigating the process, where AI is going to make less of a difference. Um, and but where it may make more of a difference is in reducing the costs and the difficulties to providers of facilitating these appeals. But as Dr. Kohane noted, it also very well may ultimately be used by insurers if it's not already being used by insurers. Again, we don't know for sure. Insurers say they're not using it to respond, and so we may end up getting battle of the bots as you envision. And so I think there are a lot of uncertainties there in that process, but I don't think that it's going to be the solution. I think it will be maybe one small part of the solution, but I certainly don't think that we can say, well, AI is gonna solve this problem by empowering consumers, and so we ought not worry about other interventions.
So I think it's not, I think this was well stated by the way, forgive me, I'm going to call everybody by their first names. So much easier. I think Daniel phrased it and framed it correctly. And if I were to bet, he's probably right, but I wouldn't say super obviously right. I think, if I think there's a 30% chance that he is wrong. And here's why. Right now, yes, it's the process. The process but the process itself is becoming much more automatic and transactional and computational. In fact, back in 2022, I heard Bill Gates say that he saw that there was going to be a war between the AIs increasing billing and trying to decrease reimbursement, and which was ironic because Microsoft at that time was definitely hosting most of the systems on both sides. So it was like in the gold rush, people were selling pickaxes who made the most money. But the point I'm making is because of this war, all those transactions are become just electronic transactions. And when you have that, if there is a financial incentive, you can actually have very simple to consumer agents that will do the whole business. It'll just say, go argue with them. And here's all my health data, which under the 21st Century Cures Act, you can actually get in many, many hospitals, and just argue with that. And so the question is there a business case that's going to be generated? And I've been talking recently with Jonathan Zittrain at the Berkman Center, and from a conversation that we've had, it's pretty clear the key issue is, will the consumer AI agents get full access to the information that is being transacted over by the payers and the providers? If they are, then they will have it, and then groups like AARP will have actually major financial incentives to actually go with those tools. But again, as a betting person, Daniel's more likely to be right. But I think there are foreseeable outcomes where, in fact, the patient has too much power, and people will want to insure less, because in the end, these values always pit patients against society, because I want the most for my care. But the way insurance works, it's distributing risk. And that means that some people don't get as much as they would like.
We seem to have switched to first names. So Jen, did you want to comment on this? Particularly whether there are subcategories of patients for whom these barriers are higher, they're older, they're less resourced, they're terminal, you know?
Yeah, I think that's the thing. When Dan was talking, I just started thinking about when people usually ask me, why do people not appeal? He's absolutely right, because folks don't know about the appeal process. It's not worth it to them. They just switch what kind of care they're going to receive, and they sort of, just accept it. But a whole bunch of people don't appeal, even if we simplified this or gave them all the AI in the world, because they're laying in an ICU hospital bed because they are severely disabled, because they have intellectual or cognitive disabilities, because they're older and they don't have any supports at home, and they've never used ChatGPT or any of this stuff, so that doesn't make them feel any more comfortable, and they don't even have the resources. A lot of times when you're denied, especially in this post-acute care Medicare Advantage context, you have just had a serious invasive surgery involving a often complex or debilitating healthcare problem. So there are going to be categories of people that, no matter how good these companies make this competitive, consumer-facing AI for appeals, they're just not going to have the resources and the ability to take advantage of it.
Okay, I want to go to our number one question here in the QA and combine it with another. How do you, if you're the patient, how do you even know? How do you know whether AI was used, how it was used, what's going on here, what role it's playing in the insurance companies saying no so far? And our number one question is, when insurance companies do use AI to make decisions, do they have to disclose that? How do you even find out?
That's a good question. So generally, they are not legally allowed to solely rely on it, right? And so there's not really a mechanism for disclosing it, because sort of formulaically relying on it is not allowed. Now, there are some difficulties there with that. So one is, even with some of the rules I mentioned that say, okay, you have to have an individualized requirement, those only apply to medical necessity determinations. And so if you have a coverage denial that's not based on a medical necessity determination, but that's instead based on a particular coverage provision, then there is not any, as far as I am aware, requirement that an algorithm or an AI is what made that determination. So what you have to do is you have to get the rationale, the claims denial letter, and see, okay, first, is it being based on a medical necessity determination or not? If it's based on medical necessity determination, at least in theory, it shouldn't have been relied, so there shouldn't have been based solely on an AI. But what then you don't know is, okay, did some human ostensibly review it, but in reality just spend, a second on reviewing and say, yes, that looks right. And right now, I do not, again, as far as I know, there are not any rules out there that require a disclosure there. Part of the problem is it's such a fragmented system, right? Because we have state rules, we have employer rules that under ERISA, we have rules regarding Medicare Advantage. And so all these different rules, there isn't really a centralized place to look. So that's my sense. I don't know, Jen, if you have a better answer than that.
I never have a better answer than you, but I will say that the new CMS and the Medicare rules do say you have to be transparent about the use. So they're assuming good behavior and that we have the human in the loop, but they say you have to say it. Second, if you get in the weeds of the lawsuits like I've been, there's disputes between the insurance companies and the plaintiff's allegations about whether they notified some people or didn't, and they started doing it at a certain time instead of other times. And one of the interesting things is they tried to get rid of one of the plaintiffs because they had it in like Times New Roman font .1 at like the back of the letter and like this little teeny tiny font at the back of the sort of explaining letter, and the guy was like, I had no idea what that even meant, or so they're actively acknowledging that they did it in that specific instance to try to gain a legal advantage because they're bringing one of their defenses is that he was on notice and he's run out of time.
So
Jen,
go ahead, Dan.
do you know, were those just for the Medicare Advantage rules?
Yes.
Yeah, so that's part of the issue, right? So those are
Yes,
the
yes.
new rules, the regs that came out for the Medicare Advantage rules, but then that doesn't apply to the many insurance policies out there that are not Medicare Advantage. And under state law, most state laws don't have any specific rules on AI except for the states that have passed the requirement that humans be involved. And then where there's just tremendous ambiguities, what does that mean? Right? Like if I have an AI that gives me an answer and I just click submit and I, think about it for a second, have I satisfied the rule or not? Because there's not even clarity on that, I don't think there's clarity on disclosure of how the AI is being used.
Well, and Zach, your work on values would suggest that not only do you want to know how was AI used, how was it used, how much of a human in the loop was it, the 1 second push a button or real human in the loop, but which AI, because your analysis suggests that could matter enormously.
It matters enormously. It's like saying, I don't care if it's Dr. Jones or Dr. Bill who is doing my neurosurgery, because I know that Dr. Jones is aggressive and then Dr. Bill likes his golf game and won't be aggressive, or maybe I want someone conservative. They're that different, and it's fascinating. It's a whole sociology how both the methodology and the corporate culture ends up aligning these models in particular ways. Again, they're aligned broadly. They're not actually aligned about these individual cases, but these models are actually capable of sufficient generalization that these values diffuse throughout the model and affect it. And it's remarkable that we're not thinking now about what should the voice be of doctors, of patients, of governments, and so on in these individual models. They are not all the same.
So we've got a whole lot of questions about, so what do we do?
So I have a cheap answer, but I really believe it. We need to have much more of a public conversation. And the public conversation has to say these things, whether we like it or not, even if they're not being used in a particular way right now, they're going to be, because medicine is really under immense stress, and it's the impetus to use these tools is growing, and first and foremost in the financial part, but elsewhere as well. And like I was telling you, open evidence is being used by millions of doctors, hundreds of thousands of doctors in the United States. Can I tell you how it behaves compared to an average doctor? I have no idea. And so I think we have to first have a public conversation, recognize this is happening, not say this cannot happen. The horse is out of the barn. But say, how do we want it to happen? What kind of, just like we say, what kind of doctors would we like to have? What kind of AI would we like to have?
Jen, do you want to talk about your FDA proposal?
Yeah, so someone had a question about this in the chat, so I thank you. That felt very kind to me. So here's the bottom line: FDA does not regulate these clinical or these coverage algorithms. They do regulate clinical algorithms under their software as a medical device authority, and thereby risk classifications and certain ones of these that are high risk use have to do a whole bunch of stuff and go through a pre-approval process with the FDA so that they're clinically and technically validated as, having a low error rate, et cetera, by the FDA before they can be deployed on patients. So in this article, I argue, for one reason is because of what Professor Schwarcz has been telling you, is there's insurance regulation is so diffuse. If you don't have like a single national standard, you have to like go out and deal with the states, and then state Medicaid, and then state employees are different because they're ERISA exempt, and then ERISA plans, and Medicare. My argument was like if there's one national rule and the FDA just says we're going to do this somewhat similarly, and we already have a model that we do clinical algorithms and create sort of a risk classification. They would be able to at least say to patients, this product has been approved by the FDA. These are the ones you should buy that have been validated. And the benefit to the vendors of these products, and to the extent the insurance companies that have bought them and own them now, would be much more protection from lawsuit, because you get to hide in the skirts of the FDA, so to speak, and preempt some of these state law claims. So that my argument is just people die while they're waiting on these appeals, especially people who are in really critical condition. And I just personally believe that we should be doing more to protect patients on the front end, rather than talking about humans in the loop and all. Those are all good improvements, but for me, it's insufficient. And I think the litigation sort of illustrates how insufficient it's been.
So, Zach, I don't know whether you have a reaction, because you were saying don't regulate.
Right.
Yeah, I think regulate, what I really said was don't regulate now. Because right now, the kind of things, let me give you an example. Well-meaning executive order by the Biden administration had things in it like, if you have this many trillion floating operations per second, it's dangerous and bad. That's bizarre and doesn't map onto the reality of where the danger is. And so I do think what we need first is to understand what we want. And I can tell you, I had a meeting 2 years ago, international meeting that I hosted, where we had groups, regulators from all over the world come. And afterwards, the Europeans came up to me and thanked me personally for having a meeting, because he says, in all our meetings, all we're talking about is safety regulation. We're not talking about how we can actually use AI to help the 400 million European citizens. And so our healthcare system is broken. There's many ways it can be used. And what we don't want to have happen is that the richest, most powerful companies lock down the regulation. And I don't want to be unpopular, but I think that HIPAA, for example, started as a very well-meaning set of regulation, and I was very excited about it. And I was much younger and more naive. But then the big players came to play into it, so that the only real restriction to flow of data was to patients and to researchers. Commercial outfits had trivially easy access. So I'm very worried about premature regulation because we'll be regulating the wrong thing and we'll be protecting the rich and the powerful.
Dan, did you want to comment?
Yeah, so my view on this actually is pretty clear, which is I actually don't really think the fundamental problem is with AI and algorithms. I think it's with the way we regulate claims determinations. And I do think I think this is not a new problem, and this is an issue we can fix and should fix through regulation. So I would just point out a few pieces of this. The first thing is it's bizarre and weird that we have all these different systems for employer-sponsored plans and non-employer-sponsored plans, and we have all this these different rules across states, and it just makes it all a much more opaque, difficult system. But it's also bizarre and weird that we don't have a pretty systematic set of coverage rules for what is medical necessity that is set at the national level and binding on all insurers, and that we don't have our primary way for actually adjudicating disputes is not public. So external reviews, which are, probably the sort of most functional elements of our system. Not that they're great, but they're reasonably functional. They don't publicly release decisions or opinions or information. And so, today if I get a medical necessity determination that this one particular procedure for this one particular case is not appropriate and I appeal external review and I win, great, I win. But then the insurer can go just do the exact same thing tomorrow, and no one knows that I win. And there's some case that's analogous. And so we don't have any sort of public repository of information. And meanwhile, there's no litigation because of and so I think we need to fundamentally reform the way that we adjudicate claims. And what I'd frankly like to see is a single national system for establishing what's medical necessity, a requirement that all insurers provide medical necessity up to a level, like a base level, and maybe even have a few tiers, right? Maybe even have, and then a public, transparent system for developing a common law on what's medically necessary. So everyone's operating on the same set of rules, as opposed to allowing insurers to dictate this secretly and then to have these crazy disputes. So I think if we fix the system for coverage determinations, actually will go a large way to fixing some of the problems we've identified with AI and algorithms.
I want to completely agree with Daniel, and I am completely agreeing with Daniel, that it's around transparency and fixing it. I want to also be clear that the lack of transparency also benefits in bad and evil ways healthcare providers, and they do all sorts of very perverse things in order to maximize their income, including actually doing things to us that they should not be doing because they get paid for it. And I think that if we have the right public discussion, we can actually ask for that transparency. The lack of it is what is causing. Again, we have a $5 trillion healthcare budget per year. $5 trillion. Of that, at least, this is a lower bound estimate, 30% is administrative costs, because figuring out who should be paid how much, there's so much fiddling around that if it was much more straightforward, we could easily have that or quarter it. And so I think Daniel's absolutely right. And the reason that there is not such transparency is because there's so much to be gained by certain parties to keeping it obscure. And in a very related topic, Mark Cuban has been fighting the good fight with the PBMs, the pharmacy benefit management systems, who've turned obscurity into an absolute goldmine.
I would like to jump in. It's really exactly on this point, which is a number of the questions and this conversation leading me to ask, what is the particular harm to be regulated or addressed by AI? Because it seems that the system pre-AI, 2019, had a number of these features and concerns, and the literature is pretty right. It's not my area. So in other words, it's not a great system, and now AI is going to come in and mess it up. is the concern that AI is going to exacerbate issues, that it's just going to sort of not solve the problem and distract from larger issues? What would be the particular harms that you'd want the soon to be, perhaps, if not today, regulation to really be focused on? And I guess I'd give a concrete example. What if it was just a really advanced Excel sheet, which, they're using? What is the AI component here that we'd really want to target?
So every single case, I know, and I really don't have a dog in it. I don't have a major stake here, but every single case is different. If I were to write a simple rule about which patients should get authorized and should not, I could always find exceptions to whatever rule I developed. And so we really want to have a very nuanced understanding of how that happens. Now, at pre-AI, we're a bunch of human beings and adjudicating claims. And for sure, actually, I don't know this for a fact, but I imagine that they were trained in a certain way, so they would be biased in a certain direction that was fair, but maybe would preserve some financial performance for the payer. But there was a distribution, and there'd be more generous and less generous claims adjusters or authorizers. Here, the danger is, the dystopian danger is really enforcing a policy that either a great policy or a terrible policy. It's the scale of, and it becomes harder to appeal.
Yeah, I mean, I think there are a few pieces, most of which are an outgrowth of the problems with the broader system with coverage determinations. Though, again, I agree, there are tremendous benefits here too, as well. And it's not just with the generative AI that's empowering consumers. I do think it's with allowing insurers to make more informed decisions and potentially to limit medically unnecessary treatment. So I think it's not just gee, there are costs. There are benefits and costs. But I think, one is, of course, the individualized determination, right? I mean, every medical case is distinct, and it may be that to an AI that is trained on a particular population or based on an algorithm that has rules that seem reasonable ex ante for the general population, that's not appropriate for individuals. And what ends up happening then is not only that people are denied medically necessary care, but it also imposes massive costs on providers to navigate the system. And again, something I again increasingly see is I think providers increasingly are getting so cynical and so fed up with the system that they're manipulating diagnoses. They're manipulating what they write down in the charts just to get care for their patients. And so they'll fabricate symptoms. They'll say, "Oh, well, don't you have this symptom?" And put it in the note. And so the entire system is becoming even more opaque and difficult to manage and full of gaming and strategy. And that's just not, I mean, so where's this really showing up? I mean, look at what's happening to health insurance premiums, right? And there are a lot of reasons for that. I mean, I'm not going to claim that AI or claims is a big part of it, but it is part of it. The complexity of the system, the administrative costs, and so increasingly, healthcare is just becoming unaffordable. A typical health insurance plan might cost $30,000 a year for people. I mean, like for a family plan, that's just completely outrageous. And it's not stopping, right? What do we have? We're continuing to have rates of healthcare inflation that are above. We need a better system. And I think the real concern I have with AI is it's going to even further embed the complexity and the opacity of our current system. So we fail to deal with the question of, look, we need to be able to answer questions like, okay, should someone get an MRI if they have a 0.5% chance of cancer? And if the MRI costs $3,000, and if the MRI is going to produce, a 10% chance of diagnosis that then would lead to, we need to have just answers to those questions and right now we have no answers to those types of questions. It's just completely in the void. And
That's absolutely right. But again, people, I think appropriately, are suspicious about insurance companies. But I want to tell you that a lot of my colleagues who are in full-time clinical practice are getting weekly emails from their department chairs, clinical department chairs. Hey, your RVUs, the reimbursement units are down this week. What's going on? Are you upcoding? Are you picking the right codes? To maximize billing? And there are roomfuls of individuals in the basement of many hospitals whose only job is to look over the record and say, well, could we get more money if we bill that code? Decreasing accuracy of the billing, by the way, which is of importance to the way we understand our healthcare system. And by the way, those people are being replaced by AI because it can do it faster, cheaper. So I think when you said the doctors are getting increasingly cynical, for good reason.
Jen, did you want to get in a last comment?
The only thing I'll say is I agree with everything that's been said, but these insurance companies are not paying $2.5 billion that they're not going to get back and convincing their shareholders that that's a good purchase. They're going to use it to deny claims. They did that before, but it wasn't as cheap, fast, and as efficient as it can be with the AI layered on. It's expensive to pay doctors and nurses to sit in the basement and do this all day long.
Well, we're going to have to close out here. What a great discussion of what a big and troubling set of issues, and fantastic questions and comments. Thanks to all of you. Remember, we really want your feedback. If you take a few minutes to give us the evaluation you're about to get by email, use and share the video that will be posted immediately after. And big thanks to everyone for being part of today's webinar. Stay tuned for the next webinar in our ongoing series exploring when law, ethics, and medicine collide. Thank you.